All right, welcome back to another episode of Divorce Well in Florida. And my name is Matthew Waring. I'm here again with my partner, Brian Dunmire, and together we are Fairway Law Group. We are a Florida divorce law firm. We have two offices, one in Orlando, one in South Florida, but we take cases pretty much all over the state. Today, we're going to be talking about senior divorces or silver divorce, which we've seen a lot of recently. Probably more so in Florida because you got a lot of older couples that are still moving down to Florida, especially after COVID. A lot of them have relocated down from other states. So Florida has a higher concentration of older people. So people, and I hate to offend anybody, but age 60 plus is who we're talking about today. So Florida, we probably see more senior divorces or older couples getting divorced in Florida just because there's a higher number of older people here. But regardless, there definitely has been an uptick in the statistics of older people getting divorced. And, Brian and I probably each have similar or different reasons or explanations for why that may be the case. Personally, I think it's because of when people get older and they retire and they're drawing on a pension or they're drawing on Social Security or they're living off their investments, there is no longer a breadwinner in the home. There's no longer one person who's bringing in a majority of the income due to a job. And when that happens, there's less reliance on each other in the marriage. And since the other partner might have been sticking in that marriage to stick it out with the breadwinner because they had a high paying job, when that person retires and they're just living off of retirement, which can be divided 50-50 in equitable distribution, might not be as much incentive to remain married anymore. We also see kind of the midlife crisis scenario, which is odd. It seems to happen later and later. Instead of people going through their midlife crisis in their late 30s or early 40s, we're seeing people in their late 30s and early 40s. That's in their prime childbearing years these days. People are having kids later. So those midlife crises are happening later and later, well into somebody's 60s, early 60s, late 60s, early 70s. That's when people want to go out, empty nest, they're done raising their kids, they want to party, they want to ride motorcycles, and do whatever it is that older people like to do. Brian, does that kind of line up?
Yeah, I think it definitely lines up. And senior or older divorces definitely, on one hand, sometimes can be a little bit more straightforward because there's not going to be minor children involved a lot of the times. On the other hand, it could be a little bit complex if there's a lot of assets that have been accumulated over the course of their lives. Then you work into Social Security, pensions, things of that nature, retirements, splitting up retirements, and it can create some issues, or it could be a little bit more straightforward if there's not a ton of assets and people are living off of Social Security or retirements.
A lot of the standard issues that apply to all divorces are going to also apply to senior divorces or to getting divorced if you're older, except there's some very specific things like Social Security, for example. So Social Security is not going to factor into equitable distribution. So if somebody's receiving Social Security, even if the other spouse is not receiving Social Security, that spouse that is receiving the Social Security is not going to be obligated to split their Social Security payments in half. It cannot be equitably distributed. However, it can factor into total income for purposes of calculating alimony. So you've been married for a long time. Maybe you're a high income, high wage earner and you're receiving a fair amount of Social Security. Even after taxes, if you get divorced and your spouse doesn't have Social Security, they never worked, and they can't claim off of yours, then you might be in a situation where you're paying some alimony out of your Social Security. Another thing to know about Social Security is that, and I believe, I'm not a Social Security expert, but I believe if you've been married to somebody for at least 10 years, you get to claim off of their Social Security. But I think the benefits might be somewhat prorated. I'm not exactly sure how that works. It'd be best to speak with Social Security or speak with, a lawyer or an expert in Social Security to find out exactly what you might be entitled to. But I know that there is a 10-year, if you've been married for 10 years, I know that you can claim off of your other spouse's Social Security.
One thing to take note of that I think as an attorney, a really interesting topic. It doesn't apply to everybody, but if it does apply to you, it's going to be very important, and that's going to be pensions. The high level overview of pensions is that they are subject to equitable distribution. but it's not every single dollar that you've earned, or it's not the entire pension necessarily. The way that pensions are calculated, and this is going to be at a very high level, is you take the number of years that you worked. So let's say you worked for the phone company for 20 years. Even if you've been retired for 10 years, I worked for the phone company for 20 years. And of the 20 years that I was working for the phone company and contributing towards the pension out of my paycheck, I was married for 10 of those years to my wife or husband, who I'm now divorcing. And in that scenario, 50% of the pension is going to be considered marital. So if your pension payment's $1,000 a month, in theory, $500 a month is going to be marital. And then the way that that gets paid out in equitable distribution is most likely going to be through an income withholding order on a monthly basis. So in the scenario that we just did, $1,000 a month, where 50% of the pension is equitable or part of equitable distribution, the spouse is going to one half of the marital portion of the pension. So if the marital portion of the pension is $500, you get one half of that, so $250. Whereas say the entire pension is marital, then you're going to get half of the pension, which would be the 500. So just remember, it's one half of the marital portion of the pension.
Marital portion is going to be defined as the portion of the pension that covers the lifespan of the marriage. So, for example, if somebody started paying into a pension, they've been paying into it for 30 years, but you were only married for 20 of those years, then only 2/3 of the pension would be considered marital, of which that 2/3 then is split 50-50. So even if you've been married for 20 years, which is a long time, you're not going to get credit for those 10 years that your spouse was paying into the pension before the date of the marriage. Brian, if you could just define pension, because when people hear the word pension, they think 401k, they think Social Security, they think disability, they think any sort of retirement income is a quote unquote pension. But a pension is a very specific thing, which not a lot of people have.
Yeah, it's going to be mainly people who work for the government. So obviously in Florida, if you work for the Florida state government, lots of teachers, college professors, police officers, they have pensions, things of that nature. That's going to be what it is. And of course, there are some businesses out there that offer pensions. I think they're getting less and less over, in modern times, but they're still out there. And if we're talking about senior divorce, somebody who retired from Verizon back when it was whoever it was before Verizon, they might have some sort of pension that would be considered marital. If there's a lot of tricky things about pensions. You're probably going to need to get an expert to value it, which is not astronomically expensive. It's not tens of thousands of dollars. It's formulaic. But the reason why is because ultimately what we're going to want to do as attorneys in a litigation proceeding is to reduce the value of the pension to the present day value, which is an econometric type calculation that needs to be done by an expert. And there are experts who do it. We do need some minimum information. Typically, the most recent pension statement or something along those lines is sufficient to show the data points in it. There is one thing in pensions that is tricky, and that is the survivor benefit. So if your spouse or if you are retired, typically in pensions, what you have to do is you have to elect a survivor benefit, which means upon my death, I want this to happen with my pension. All pension plans are different, so this isn't uniform across every pension plan. But for the most part, once you make that election, it cannot be changed. Okay. So if John Smith is married to Mary Smith and John Smith has a pension and he retires and he says, from my monthly pension payment, what I'm going to do is I'm going to withhold $250 a month to put towards a survivor benefit. And then upon my death, Mary Smith is going to get, say, 75% of my pension until her death. Okay, that's called the survivor benefit. There's not a ton of case law out there in Florida on that. And it can definitely skew equitable distribution one way or the other. Because if you reduce that payment to a present day value, it can be quite significant. And then depending on which column it gets imputed into, the husbands or the wives, it can have a big effect on equitable distribution. So You don't need to understand every single concept of it. You don't need to understand the present day calculation. You don't need to know every single fact about it. But if you take nothing away from this podcast, if there is a pension in play, whether you have a pension or the opposing party has a pension, it's something that needs to be looked at or should be looked at sooner rather than later. Without going to attorney on this, there's all sorts of reasons why you might want to wait to do it or whatever it might be. But nonetheless, ultimately, if a case is proceeding to trial, there's probably going to need to be an expert to calculate the value of the pension so that it can be distributed correctly. So just something to bring to the attention of whatever attorney you go with.
And it sounds a lot more complicated than it really is. I mean, the experts can calculate these things in an hour or less a lot of times. So it sounds a lot more complicated, but we can get that information relatively quickly in a case. And like Brian said, it can dramatically change the entire landscape of equitable distribution if there's a pension involved. So that's always recommended. Another thing is 401ks. There's going to be a lot more 401ks out there than there are pensions. Pensions are really going to be government employees. They're going to be people in the military. They're going to be people that work for those companies that have been around for 60, 80, 100 years that still do pensions. But 401ks are going to be the bulk. And the 401k is going to work somewhat similarly in the sense that the marital portion of the 401k has to be determined. And that's going to be determined by how long you've been married and when the contributions began and how much contributions were made during the marriage versus before the marriage. And that can get very tricky in a older divorce because it might be a couple that has been married for 25, 30 years, and maybe they've been contributing to a 401k for 40 years. Do you have all of your 401k contribution statements from 40 years ago? Probably not. And the financial institution might not have it either. So it gets very difficult to discern, and it honestly could be cost prohibitive to actually do the discovery necessary to find out like what the precise marital portion of the 401k is. But assuming that those aren't issues, the 401k can be divided without penalty and without tax implications. A 401k does not need to be liquidated and split in half in a divorce. We can also get, specialists involved who can draft something called a QDRO, Qualified Domestic Relations Order. And the specialist is going to work with the financial institution that holds the 401k account. And they're going to make sure that they draft a court order that the judge can sign in your case that's going to authorize the financial institution, make them feel comfortable enough to divide the accounts into two, depending on the split that you agree to in the divorce. A lot of times it'll be 50-50, but we've seen them 60-40, 70-30. It just depends on the circumstances. But the financial institution will bifurcate those accounts. They'll create two separate accounts, one with your name, one with your spouse's name. And the money will be split up, and there will not be a taxable event, and there will not be any penalties associated with it because it's not an early withdrawal or anything like that. It keeps the money invested. You each then can just move on and control your own account. And you can't see what's going on in your wife's account. Your wife can't see what's going on in the husband's accounts. They're going to be completely separate accounts, new account numbers, and all that. But that has to be done with a court order because the financial institutions are not going to split up those accounts without these QDROs being in place. So that is something that if there is a big 401k account in your marriage and that's going to be part of equitable distribution, you got to have that on the radar. A lot of older couples have multiple homes. Not everybody. I mean, it might sound like a luxury, but I think the last time I saw the statistics, the average household over the age of 60 owned 3 homes in the United States, which is a tremendous amount of homes to be held by a very small group of people. But those homes are not always going to be owned all within Florida. There might be homes owned in different states. You might be somebody who's come from another state who has a house in Michigan. You might have a house in Arizona and a house in Florida or a condo in Florida. And all of those assets are all going to need to be equitably distributed in the divorce. The easiest way to do that is if you guys can work out an agreement. I'll take the Arizona house, we'll sell the Michigan house, spouse will take the Florida house, whatever the case is. But if it can't be worked out, and there can't be an agreement, then all the homes where an agreement falls through on who's going to take over is going to have to be sold. and the profits are going to have to be split up equally in the divorce.
Going back to the QDROs, so again, the QDRO is just the document or the process that goes on after a domestic order is issued that allows money to transfer from a retirement account or some other account to another account without tax implications. A practice pointer is when you do a QDRO, if you were to retain us, we'll assist you with it. We don't actually do QDROs. Very few family law attorneys actually do QDROs. In fact, I don't know any family law attorneys who do like divorces and QDROs because QDRO experts do them. And again, it's not cost prohibitive or anything like that. But when you're actually transferring the money, it's better to put, this is what I've been told, and this is what we try to do as much as reasonably possible. Instead of saying 50% of my husband's 401k account, 50% of my wife's 401k account, it's better to agree on an exact number because obviously if it's invested, it's going to fluctuate a little bit up, a little bit down, maybe a lot up, maybe a lot down. And so, there's a benefit of the bargain there. It could go up, it could go down, but at the end of the day, it's a little bit easier to put 50% or an exact amount, $125,000, irregardless of the value of the 401k on the date the QDRO is applied. Because sometimes when you just put a 50%, if it's not indicated exactly what that 50% is based off of the date the QDRO is processed, the date the money actually gets transferred out, it can just result in delays or essentially more work or questions being asked, and nobody wants that. So a little practice pointer that we've learned over the years here.
Yep. And another issue is going to be dating after divorce for older people. It's interesting. Florida has, I think, the highest population of single people over 60. And kind of all jokes aside, that's not all centered in like the Villages area, but they're all over Florida. One of the biggest issues is going to be with alimony because you're talking about older people that have been married 20, 30 years. They might qualify for a significant amount of, one spouse might qualify for a significant amount of alimony for a very long period of time. So if you've been married for 30 years, you might qualify for 22.5 years of alimony under the statutory guidelines. And that could be just, you name it, a significant amount of money over a long period of time. And if that person that's entitled to the alimony ends up dating and shacking up with somebody else and they move in together and it's after about a year goes by, living together, not even remarried, the spouse who is ordered to pay the alimony can file a petition for modification to have the alimony completely removed because of the former spouse living with another partner for up to a year. So that's something to keep in mind, that if you are going to be the spouse receiving alimony, you're basically abolished from moving in with somebody during the remaining alimony term. If you're somebody that's paying alimony, you want to pay attention to whether your spouse moves in, moves on, dates somebody else, moves in with somebody else. Because once they've been living with somebody else for a year and sharing expenses, you might have a very strong case to modify to terminate alimony.
Once the divorce is finalized, and yes, I do mean finalized, signed, sealed, delivered, make sure you update your estate plan to have your will say whatever it is that you want it to say. A lot of estate plans do have provisions upon divorce in there or whatever, but you don't want to rely on that. Just go do a new estate plan. They're not extraordinarily expensive. It'll help your heirs a lot when you pass away. And then also included in the estate plan would be some sort of healthcare surrogate or healthcare designation form. Maybe you get divorced and you and your spouse are perfectly fine. You just don't want to be married anymore. And if that's the case, maybe they still are the first person who gets called. God forbid you're incapacitated or vice versa. But if you go through a contentious divorce and you don't update your estate plan and your spouse is listed by name as the first person who gets called if you're incapacitated. Hopefully they still act in good conscience, but just remember to update your estate plan. Nobody wants to think about it, and it's certainly not pleasant. But if you're dead set on getting divorced, and you were having some serious health issues. Again, nobody wants to think about it, but maybe you're about to look into going to the hospice or something along those lines. There is a mechanism in Florida to finalize the divorce quickly for the purposes of actually being divorced upon your death. And then it reserves the equitable distribution as it relates to the estate or whatnot. That's called a bifurcated proceeding. If you're listening to this, but you're not a senior divorce, don't think that you're going to be able to just get a bifurcated proceeding so that you can get divorced and then remarried. That comes up a lot. Hey, can I just get divorced and we figure out everything later? No, of course don't do it. The only exception in the case law to that is, unfortunately, when one of the parties is on a brink of death, hospice, something along those lines. Florida courts will say, yes, we will grant a divorce for the legal purposes of divorce and reserve on the issues of equitable distribution or whatever it might be. And then that would be handled by your estate or your spouse's estate. So just something to keep in mind if you're in that scenario.
Even if you just have, health issues going on, and something to keep in mind is that once you get divorced, you will no longer qualify for your spouse's health insurance plan. So if your spouse is still working, has a good quality health insurance plan, and you're a member on that plan, once your divorce judgment goes through, the other health insurance company is not going to be allowed to cover you anymore because you're no longer going to be considered related. You're not going to be considered family anymore. So you're going to have to go out and get your own health plan. And your spouse is not going to be required to pay for a new health plan for you. If the spouse is ordered to pay alimony, you'd have to use that money to go out and purchase your own health plan. Or you might have to go out and get a job with an employee-sponsored health plan, or you're going to have to purchase one on the open market, or if you're old enough, can get on Medicare and pay for some sort of supplement or something like that. But we can't work out a deal where you get divorced, but you remain on your partner's health insurance.
That's impossible and prohibited by law. So just take into account that you might lose health insurance. I suppose maybe there are some very specific exceptions, again, with pensions, if there's some sort of designation at the time of retirement. But generally speaking, you should just assume that if you're getting health insurance through your spouse, that you're going to lose that upon the final divorce order, the decree of divorce that gets entered by the court.
What we see a lot in practice, which does not go to any like procedural aspect of the divorce or any money or anything like that, is these older divorces can create a huge rift in families with adult children. You can have adult children that are going to side with one spouse or the other. Or you're going to have a situation where the adult children all gang up on one spouse and all push one of the spouses to get divorced from the other. And it can create a lot of problems and a lot of friction. The best thing to do, and this is the same advice we give for anybody going through divorce, is just to be as civil as possible. But, to also loop in the adult children, have a conversation with them ahead of time. This is what we plan to do. Even though your children are adults, they're still your kids, and you still need to try to make the transition as easy for them to tolerate as possible. Because even though they're adults and they're grown human beings, they still have feelings, they still have emotions, they still see you as mom and dad, and they can still have a problem with the fallout of getting a divorce. So even though they're adults and they might be in their 30s or 40s and have kids of their own, it can still mentally affect them. So we always encourage people to try to not use your adult children as a sounding board. Don't use your adult children as your mental health counselors to get you through a divorce. Don't try to recruit your adult children to gang up on the other spouse. It's just not a very good thing to do as a parent, even a parent of adults. So with that, thank you for tuning in to another episode of Divorce Well in Florida. My name is Matthew Waring. I've been here with my partner, Brian Dunmire. And again, we are both the shareholders at Fairway Law Group. We represent people getting divorced in Florida. We also do some select paternity cases, some modification cases. And we have a lot more resources on our website, and we hope you guys stick around for another episode.